I mean, you walked all over the Constitution throughout this entire process.
Mr. Chairman, the gentleman's time has
spying
expired.
on members of Congress, and you know it. It's absolutely disgraceful.
I'm Brand Cooper, and before we get into this next clip, I want to be clear right up front. This is not a new hearing. This is actually an older clip, but it's resurfacing for a reason. And honestly, once you watch it, you'll understand why it still matters. So here's what happened. Brandon Gill, a freshman Republican from Texas at the time, used his time on the House Judiciary Committee to try and grill Jack Smith. The focus was Smith's investigation into the attempts to overturn the 2025 election, specifically his decision to subpoena phone records belonging to Kevin McCarthy and several other Republicans. And Gill clearly thought he had something here, like a gotcha moment. He zeroed in on a non-disclosure order and tried to frame it as something secretive or suspicious, maybe even, part of a bigger conspiracy. The problem is, it wasn't. What he's reacting to is actually standard legal procedure, the kind of thing that happens all the time in serious federal investigations. And that's where this clip gets interesting, because instead of exposing wrongdoing, it ends up exposing confusion, or maybe a deliberate attempt to blur the line between routine investigative safeguards and something far more dramatic than it really is. So as you watch this, keep in mind, again, this is an older exchange, but also notice how current it still feels. The same talking points, the same framing, the same loyalty to Donald Trump shaping the entire line of questioning. Let's watch the clip. And when we come back, I'll break down why this supposed gotcha doesn't land, what's being misunderstood here, and what this moment actually tells us about how these hearings are being used.
For 5 minutes.
Mr. Smith, in January of 2023, did you subpoena then Speaker of the House Kevin McCarthy's toll records?
Yes, sir, we did.
Yes, you did. And the subpoena covered the time period between November 2020 and January 2021. Is that right?
I'm sorry, sir, could you say that again?
We're not going to delay like this. The subpoena covered the time period between November of 2020 and January 2021. How many days after Kevin McCarthy was sworn in as Speaker did you subpoena his records?
I don't recall, but those two things had nothing to
It
do
was
with one.
16 days after becoming the highest-ranking Republican in the House of Representatives. You subpoenaed his toll records. Do you agree that that might reasonably be considered a violation of the Speech or Debate Clause?
I do not, and I want to be clear that the toll
You were
records...
collecting months' worth of phone data on the Republican Speaker of the House, the leader of the opposition, right after he got sworn in as Speaker, all around the time of a major vote. That sounds like a flagrant violation of the Speech or Debate Clause to me, and I think most people agree with me. And Speaker McCarthy had no recourse, did he? Because you issued a non-disclosure order ensuring that neither he nor any of the American people knew about these subpoenas. Is that right?
The toll record, the non-content toll record subpoenas, we did secure non-disclosure orders for those subpoenas.
You did, and let me ask you, Mr. Smith, at the time you secured those non-disclosure orders, was Speaker McCarthy a flight risk?
The non-disclosure order was based on concerns about...
Was Speaker McCarthy a flight risk?
He was not.
He was not. Then why did your non-disclosure order refer to him as a flight risk? It says right here, the court finds reasonable grounds to believe that such disclosure will result in flight from prosecution.
Sir, when securing a non-disclosure order, the risks don't have to be
You
associated...
think that the Speaker of the House is a flight risk?
The question?
No, this is not your time. This is my time. You think the Speaker of the House is a flight risk? You think he's going to hop on a plane and leave the country?
No, what I was trying to explain is with respect to a non-disclosure order, the risks aren't necessarily associated with the subscriber to the phone. They're the risks to the investigation.
I think that you were using, this was clearly in reference to Speaker McCarthy, and you were using clearly false information to secure a non-disclosure order to hide from Speaker McCarthy and from the American people the fact that you were spying on his toll records. But I've got more, so let's move on. In May of 2023, you also issued subpoenas for toll records of 9 U.S. senators and an additional representative. Is that right?
In May of 23, we did issue...
You did, and there were non-disclosure orders in conjunction with those subpoenas as well, right?
That's correct, consistent with department policy and the law.
So again, nobody would know what you were doing. The senators would, and the representatives would, and the American people wouldn't know what you were doing. Is that right?
The toll records that we secured and the non-disclosure orders were consistent with policy and consistent.
And you knew
with
whenever you were doing that there was a risk you were violating the speech or debate clause. Is that right?
The toll record subpoenas that we secured were with the concurrence of the public integrity.
Your own analysis says that you knew there was a risk you were violating the speech or debate clause. I have it right here. This is an email from John Keller at Public Integrity Section to your team. As you are aware, quote, as you are aware, there is some litigation risk regarding whether compelled disclosure of toll records of a member's legislative calls violates the speech or debate clause in the DC Circuit. That's from your own analysis right there. So you did know, didn't you?
Sir, with respect to the item you just put up on the screen, the last sentence states.
Oh, we're going to get to the last sentence.
Okay.
We're going to get to the last sentence. And you cite case law in here, quote, the bar on compelled disclosure is absolute. Is that right? Or do you think that you didn't have to abide by that precedent?
To be clear, this statement is not from my office. This is the statement of the Public
This is
Integrity
your
Section.
justification for those subpoenas and NDOs that you ordered. This was part of your analysis. It's a cursory analysis. I think it's worth noting. But let's get to that last sentence then. Quote, given my understanding of the low likelihood that any of the members listed below would be charged, the litigation risk should be minimal here. In other words, you're using a novel legal theory, which you knew was novel, has never been tested by any court. You're not charging any of these members. Nobody's going to know about it because you issued NDOs. Nobody's going to sue about it, so who cares? We're going to do it anyways. I mean, you walked all over the Constitution throughout this entire process.
Mr. Chairman, the gentleman's time's
spying
expired.
on members of Congress, and you know it. It's absolutely disgraceful.
The time.
Now, you-
Okay, let me start by saying this. If that clip made your stomach tighten a little, that reaction makes sense, because on the surface, it sounds outrageous. The way it's framed, it feels like the government was secretly snooping on the Speaker of the House, slapping a flight risk label on him like he was about to disappear into the night. That's how it's meant to land. And here's the thing. That emotional reaction is not accidental. It's the entire strategy. What Brandon Gill is doing there is relying on the fact that most people don't live inside federal statutes. We don't spend our free time reading DOJ procedures, so when someone confidently throws around words like spying or non-disclosure or flight risk, it triggers a gut response before your brain ever gets a chance to catch up. So I actually stopped and looked into what this process really is. Not the dramatic version, the boring, legal version. And once you do that, the whole performance kind of collapses. Non-disclosure orders aren't some rare, sinister move. They're a routine part of investigations, where tipping someone off could mess with evidence. And that doesn't mean prosecutors think someone is going to flee the country. Most of the time, it means something way less cinematic, like texts getting deleted, call logs disappearing, or people suddenly remembering events in a very coordinated way. And that's the key point people miss. This wasn't about listening to conversations. Nobody was sitting around hearing Kevin McCarthy talk strategy or, I don't know, complain about cable news. What was obtained was metadata. Who contacted who, when, and for how long. That's it. No content, no audio, just patterns. But calling it metadata doesn't scare people. Calling it spying does. Then there's this idea that members of Congress are somehow untouchable. Like once you're elected, the law just politely looks the other way. That's not how the Constitution works. The protections Congress has are for actual legislative acts. Debates, votes, committee work. They're not a lifetime shield against scrutiny if lawmakers are involved in something outside that lane. And the email Gill keeps waving around? That wasn't some smoking gun. That was lawyers doing what lawyers do. Asking, okay, if we proceed, is this person going to try to sue us and slow everything down? That's not evidence of corruption. That's reality when powerful people are involved. What's really happening here is a sleight of hand. Instead of talking about why investigators needed to look at communication patterns in the days leading up to January 6th, the focus gets dragged to paperwork, forms, boxes, procedure. Because if you keep people angry about the process, they stop asking questions about the behavior. And let's be honest, if everything surrounding that period was totally innocent, There wouldn't be this level of panic over phone records. People don't fight this hard to hide nothing. Here's the simplest way to think about it. Investigators do not ask permission from the people they're investigating. They never have. If they did, evidence would disappear every single time. That's true whether you're a politician or a regular person, and pretending otherwise is just special pleading. Imagine if police had to call someone and say, "Hey, just a heads up, we're about to check the cameras. Anything you want to erase first?" It's absurd, but somehow, when it's powerful people, we're supposed to treat that as reasonable. Zooming out, this isn't really about Kevin McCarthy at all. It's about setting a warning sign for the future. The message is, if you investigate people with the right political label, we'll drag you into hearings, accuse you of misconduct, and turn the process itself into the scandal. It's meant to make the next investigator think twice. And, as an American, that's the part that actually bothers me. Because the law only works if it applies upward, not just downward. Once politicians start carving out exemptions for themselves, the whole system tilts. At the end of the day, this was an oversight. It was intimidation dressed up as concern. And the louder the outrage, the clearer it becomes that someone is afraid of what a paper trail might reveal. And based on how aggressively they don't want anyone looking, yeah, that tells you more than the hearing ever did. And before you go, if this kind of breakdown is useful to you, if you like actually understanding what's happening instead of just being told what to think, make sure you're subscribed to the channel. It genuinely helps support independent commentary like this and keeps these conversations going. I appreciate you watching. I appreciate your time, and I'll see you in the next one.